Proceed. Let me just check the status of the courtroom. All right, thank you. All right. Now, I understand that a number of attendees who are joining us from overseas through the webinars today. Let me just state out a few remarks, primarily for their benefit and other creditors. So just a reminder, please, these are court proceedings and they are a solemn and serious occasion. You need to treat it as if you are physically in court. Now, normally these are heard in chambers, meaning they are held informally just between myself and the lawyers, but because of the number of creditors present and because of the public interest, I've directed that this hearing be heard in open court. Now, this afternoon, the applicants will be applying for the extension of their moratorium, which basically prevents proceedings from being commenced or continued against the company. For those of you who have been looking this up, you may understand that the objective is to prevent proceedings so as to allow the company to have some breathing space to try to put together a proposal, which may take a little bit of time. In the meantime, however, there will be no proceedings against the company. And usually the company will also not be paying out in any form. So in terms of the application that is before me today, the objections will generally be legitimate if they take a certain number of or certain characteristics, and I cannot decide on the merits of the claim. The basic assessment I need to make is to ensure that a broad assessment that there's a reasonable prospect of whatever the company is proposing working out. And secondly, that it will be acceptable to the general run of creditors. Now, this is done on a broad basis, meaning that at this point, I do not normally go into precise numbers or precise details. I would also ask all of you to please note that the court is not able to give advice. The court must remain neutral. I appreciate that a number of you are not represented, and I will be addressing the applicant shortly to try to see what can be done to give some assistance at least, but that is something for you to bear in mind. I cannot give advice. Now, a number of you have also asked to speak to me either in support or in opposition, or possibly a couple of you have no position but wish to address the court anyway. I understand your concerns and that you wish to have a proper participation in the process, but because of the numbers involved, I would be grateful if each of you could speak up to about 3 minutes or so. Depending on what you've indicated, I may be able to give you more time, but I would otherwise ask you to try to keep within 3 minutes or so and to address your arguments or what you wish to say primarily to the scope of objections that I have listed earlier. Otherwise, we may not be able to complete the hearing in time today. So after this, what I will do is I will proceed with the application with submissions from the applicant. That is scheduled to take a few minutes. And then I will hear from the lawyers present and those of you who had indicated earlier that you wish to address me. Then I will return to the applicant's counsel and ask them to respond to whatever has been said. And I will also have some questions for them to ensure that they have complied the requirements of the law. In the next few days after today, I will issue written remarks, a written judgment, capturing the orders I made today and what I have considered. So this, I hope, will be of benefit and assistance to all of you who are less familiar with our proceedings. All right, so that is how we will proceed. And for the rest of the matters, we will take them as they come. With that, Ms. Ng, could I turn to you for your initial submissions, please?
Grateful, Your Honor. And would Your Honor have the written submissions that we have?
Yes, thank you. You can take it as read. You can highlight the main points.
Grateful, Your Honor. And just very broadly, as a matter of introduction, Defi Payments is part of the broad group of companies which provide online services relating to cryptocurrencies, such as lending, borrowing, and trading. And the main aspects of the business on the Vault platform have been set out in Mr. Darshan Bhajia's first affidavit. I do not intend to go into detail, but basically in relation to the business that's being operated by DeFi payments itself relates to borrowing and lending, as well as proprietary trading, whereas the exchange business is carried out by a separate entity within the board group. We have set out also in Mr. Darshan Bhattacharya's first affidavit the financial position of the company, and the reasons for DeFi payments financial difficulties have also been set out in Mr. Darshan Bhattacharya's first affidavit. In particular, I just wanted to highlight to Your Honor that the difficulties, one of the main reasons for the difficulties it's in relation to the collapse of the cryptocurrency market in recent times. And that has put a lot of financial strain on the liquidity of the company because of the significant increase in the number of requests for withdrawals that basically came from creditors, basically customers on the Vault platform, following the announcements by various other crypto players in the market in relation to their suspension of accounts. And therefore, it is in this context that we are making this application for a 6-month moratorium. In terms of submissions, I propose to address first the test for creditor support, as Your Honor had mentioned. In relation to the test, I do have to satisfy Your Honor today. I will also then deal with the statutory conditions under Section 64 and Section 63 of the order. I will then explain why 6 months is required. And also, before I get to my submissions, as a matter of administrative, on an administrative note, we do like to seek leave to amend the prayer in the originating application. And this is at prayer 1C, Your Honor. Prayer 1C reads, no proceeding, so this is the moratorium that's being sought, no proceeding whether before a court, arbitral tribunal, or administrative agency, and whether current, pending, or threatened against the applicant shall be commenced or continued against the applicant except with the leave of the court and subject to such terms as the court imposes. My proposal is to actually include the words after the word proceeding in brackets, other than proceedings under Section 210 or 212 of the Companies Act, comma, or Section 64, 66, 69, or 70 of the Insolvency Restructuring Dissolution Act. In order, this is to reflect the wording of Section 64 1C of the order.
All right, thank you. Leave granted to amend.
And in the other matter, and perhaps I can deal with it upfront, is in relation to prayer 2 of the originating application. I just wanted to clarify that upfront at this point in time, we are not proceeding with prayer 2 in relation to the moratorium order applying to any person in Singapore within the jurisdiction of this court, whether the act takes place in Singapore or elsewhere. I do recognize that it's intended, insofar as Section 64 5 is concerned, it's intended to apply to a specific act. And since the filing of the application, there hasn't been a specific act that we are concerned about at this moment in time. And so I do seek leave to withdraw this prayer without prejudice to the right of the applicant to make an application for relief in this regard if necessary.
All right. Do you seek to withdraw that, or will it suffice for me to make no order today?
Your Honor, that's fine. Not to make any order today.
All right. All right. No order today then on prayer 2. Thank you.
Grateful, Your Honor. I mean, now, if I can move to the support for the moratorium, and this is one of the key tests in relation to the proposed, into the test for creditor support in granting a moratorium. And in this case, at this point in time, Defi Payments has not yet proposed a scheme of arrangement, but intends to propose a scheme of arrangement. And in this context, we do have to satisfy Your Honor that 1, there is evidence of creditor support of the moratorium. 2, there is reasonable prospect of the proposed compromise working and being acceptable to the general run of creditors. Your Honor has mentioned it is a broad assessment, not a vote count, to take into consideration the quality of the creditor support by considering whether significant or crucial creditors are supported. And with that, Your Honor, I turn to Mr. Darshan Bhattacharya's third affidavit. I do apologize that it was filed quite late in the day, just today at 2 p.m. The reason for the filing of the affidavit following Mr. Darshan Bhattacharya's second affidavit was to give Your Honor an update in relation to the creditor support. And this creditor support, it's not new, it's actually set out already in our letter to the court on the 29th of July. But we wanted to place it before Your Honor by way of an affidavit. I have not yet provided a copy of that Mr. Darshan Bhattacharya's third affidavit to the creditors in light of the the short period of time, but we will, of course, be doing so shortly.
All right.
Yes, and it's an update. So, Your Honor, if you can turn to Mr. Darshan Baj's third affidavit at paragraph 7. And this is an update on the numbers that have already been set out in Mr. Baj's second affidavit. And at paragraph 7, since the filing of the second affidavit, 300 more responses have been received. And when I say responses, these are actually responses to a questionnaire that was provided to all creditors, asking them to give their responses to various questions in relation to attendance at the hearing, and in addition to the position on the application. Would Your Honor want to take a look at the questionnaire sample?
Yes, thank you.
Yes, and Your Honor, this is at the second affidavit at page 53.
All right, thank you.
So we had set out asking, so this was a form that was disseminated to all creditors, and they were told to respond with their name, email address, their position, attendance at the hearing, whether they're represented by lawyers. So this is at pages 53 all the way to page 55. So the third affidavit, we have collated the responses. So out of the 147,000 creditors, 3,231 of them submitted responses. This is at paragraph 7 on Mr. Darshan's third affidavit. And out of the 3,231 creditors, 2,502 of them indicated support of the application. 524, which is approximately 16.2% of the creditors who responded, indicated that they do not take a position, whereas 205, which is approximately 6.4%, have objected to the application.
All right.
Further over the page, Your Honor, at page 4.
Yes.
Yes. In Mr. Darshan's first affidavit, we had set out the list of the top 20 creditors, as required under the order. What we have done is to do a comparison in relation to the responses of the top 20 creditors, and this is in set out paragraph 8. Total value of the top 20 claims is about 125 million USD. And it is not USD equivalent because the original source of the claims will be in cryptocurrency. And we have identified of the 20 that 12 of them are in support. And the total value of these 12 creditors is about 86 million USD, representing 69% of the total top 20 claims in terms of value.
Do you have the figure as to what they represent out of the total pool of creditors?
No, Your Honor, I do not have that.
What is the total amount? Do you have a figure for that?
Yes, Your Honor, if I could go to the first affidavit.
Yes.
This would be, apologies, Your Honor, just a moment. This would be 402 million, and this is at page 7 of the affidavit. And DeFi payments liabilities set out at paragraph 15, subject to reconciliation of the interco liabilities, is 402 million USD. So the graph number is 86 over 402. About 21%, Your Honor.
All right, thank you.
Great, Your Honor. And in addition, should also set out that. Sorry. In the second affidavit, we do also set out that Mr. McGibbon, one of the creditors, has also filed an affidavit in support of the application. And he is one of the top 20 creditors listed.
All right.
Yeah. And in addition, just wanted to point out for completeness that of the top 20 creditors, the 8 creditors who did not respond, the other 8 creditors have not responded. So no one within the top 20 have objected to the application.
All right.
Your Honor, going next to the restructuring proposal in terms of what the company intends to do. So one, it has engaged with potential investors, and as a result of that initial discussions, Nexo Inc. has signed an indicated term sheet with Vault for the acquisition of the Vault platform and assumption of DeFi payments liabilities. This has been set out at Mr. Darshan's first affidavit, paragraph 32, and set out in the affidavit, the second affidavit in terms of an update. The due diligence is underway, and parties are, in continued engagement and discussions on the terms of the investment. And because it is currently at this stage of contemplation of an investment in due diligence, the proposed restructuring contemplates one, an acquisition of equity of DeFi holdings in consideration for assumption of all, if not part of the assets and liabilities of DeFi holdings. And DeFi holdings is the parent company of DeFi Payments, as well as the operating entities of the Vault Group, capital raising, as well as a scheme of arrangement for DeFi payments. And this has been set out at paragraph 36 of Mr. Darshan's first affidavit. So while at this time, there hasn't been finalized terms of any scheme of arrangement, but it has been contemplated that there could be a debt to equity conversion, a debt to token conversion, or a repayment plan. And this is all ongoing discussions together with the investor. We've also set out at Mr. Darshan's first affidavit at paragraph 35, the reasons for the applicant saying that the restructuring option of a moratorium with a view to proposing a scheme is both viable and feasible. And that's because looking at it from the group level, there is an estimated net liability of $70 million USD, which is ongoing reconciliation. There are assets available at the group level, which can be explored for utilization in the restructuring. There's also liquidity at the Vault Group level to fund operating expenses of the underlying infrastructure of the Vault operations during the restructuring exercise. With the suspension of the withdrawals, and if your owner grants the moratorium, it will also help to stabilize the business so that DeFi Payment can have breathing space to continue exploring this restructuring and coming up with formulating a scheme of arrangement to propose to the creditors. In addition, there are also positive development in relation to the search for an investor, as I mentioned, that with Nexo Inc., due diligence is underway. And with that, I'll turn to the conditions under section 64 and 63. If your honor has my submissions with you.
Yes.
And this will be at page 16, paragraph 24.
Yes.
Yes, Your Honor. So perhaps I can just go down the list, the requirements under section 64(2)(a), that there have been no orders made and no resolutions passed in respect of the winding up. And this has been set out in Mr. Darshan's affidavit. The footnote will set out the citations in Mr. Darshan's affidavit. Two, in relation to the undertaking by DeFi Payments to make as soon as practicable an application to convene a meeting in relation to a scheme of arrangement. That's set out in Mr. Darshan's first affidavit. And the second.
Sorry, which affidavit?
Mr. Darshan's first affidavit. So
first affidavit. All right, thank you. Carry on.
As well as the confirmation that DeFi Payments has not made and will not make a separate application under section 21010 of the Companies Act. That's also set out in Mr. Darshan's first affidavit. Over the page, the requirements for publication of the notice of the application in the Gazette in the Business Times. This is section 64(3)(a) of FIRDA. The confirmation is set out in Mr. Darshan's second affidavit. In addition, the requirement under the same section for service in ACRA has also been done, and this has been confirmed in Mr. Darshan's third affidavit at paragraph 14. The next one, notice of the application to each of its known creditors. This has been done on 11th of July by way of an email blast to all creditors. In this regard, the usual mode of communications with the customers on the Vault platform is by way of emails, and this has been done in notifying the creditors. Furthermore, on 18 July 2022, a copy of the sale originating application and the supporting affidavit has been made available. Subsequently, all court documents that have been filed in relation to the affidavits and submissions have also been provided to creditors of DeFi Payments. The next requirement is that of evidence of support, and this has been set out at Mr. Darshan's third affidavit, as I honor through earlier in relation to the support.
All right.
The next requirement, the brief description of the proposed compromise with sufficient particulars to enable the court to assess whether the proposed compromise is feasible and merits consideration. This has been set out in Ms. Darshan's first affidavit. And as I had mentioned to Your Honor earlier, the reasons for which the applicant says that it's feasible.
Mm.
The list of secured creditors has been set out in Mr. Darshan's first affidavit, and this is a requirement under Section 64(4)(c) of the order. Over the page, Your Honor, the list of the 20 largest unsecured creditors has also been provided in Mr. Darshan's first affidavit. Confirmation has also been given in Mr. Darshan's affidavit that it's not a company that falls under the Insolvency, Restructuring, Prescribed Companies and Entities Order. And we just wanted to highlight to Your Honor that Defi Payments is an applicant for a digital payment token license, but that's still pending. So it's not a license holder. And with that, Your Honor, our submission is that all statutory requirements have been complied with.
All right.
Heading to my next area of submission is the need for a moratorium. And very briefly, Your Honor, in relation to the claims that have been made against DeFi Payments, 2 originating claims have been brought in the Singapore courts.
Yes.
Now subject to the automatic moratorium. And in addition, DeFi Payments has received various letters of demand. The next, in relation to why 6 months is required, if Your Honor can turn to paragraph 38 of my submissions. And this is set out at page 22. The applicant estimates that will require about 6 months to carry out 1, the completion of the financial and legal due diligence by Nexo Inc. And also also carrying out the process of reconciliation of its intercompany position within the board group. So all that requires some time. In addition, the negotiations with Nexo Inc. on the terms of the proposed investment, which is ongoing. Thus, the formulation of the terms of the proposed scheme of arrangement, negotiations with stakeholders, engagement with creditors in this regard, as well as the preparation of the necessary application pursuant to Section 210 of the Companies Act. And that's for leave to call a scheme meeting. So with all these matters, it will require some time. And we are seeking a 6-month moratorium for the company to be able to carry this out. And one thing that I should emphasize is that during this period, the applicant will continue to actively engage its creditors, which he has done so. And perhaps that, Your Honor, I can take Your Honor through what the applicant has done in relation to engagement with creditors.
Yes.
Your Honor, if I can turn to, if Your Honor could go with me to Mr. Darshan's second affidavit. And this is paragraph 13 on page 5.
All right.
So the application was filed on 8th of July, and following that over the page, apart from email notifications, so we have issued email notices informing of the filing of the application, providing details on what the moratorium entails, potential ramifications of the restructuring, as well as notifying of the court proceedings, including the case conference, as well as this hearing today. Then following on the timelines that are applicable in relation to directions to file affidavits, to file submissions. More importantly, Your Honor, at paragraph D, there was a town hall that was held by the management of the company together with financial advisors, Crow. And I will discuss that over the page. In addition, the other email notices that went out were the questionnaire, as well as further directions from the court. So one thing, of course, that the company will do, and this is over the page of paragraph 14, is that it will continue to issue notices in a similar manner. That means by way of an email blast, which is the usual mode of communication. Documents filed will also be provided upfront by way of a download link. So this is done by FTP link where immediately creditors are able to click and download the documents. A town hall was held on the 21st of July, where all creditors were invited to attend. It was held by way of a webinar, live session on YouTube. And this is at paragraph 15 of the affidavit, Your Honor. And this was a very comprehensive town hall where questions and answers, a Q&A session was held. Creditors were given the opportunity to add their questions. and the management and Kroll had responded to them.
Mm-hmm.
In addition, what had happened was the management of the company together with Kroll had put together a FAQ, taking into account one, all questions that had been raised by creditors specifically to the company by way email, because an email address, a dedicated email address was sent up for creditors to ask questions. And with that, the questions were consolidated and responded to by way of an FAQ for the benefit of all creditors. In addition, specific questions that were raised during the virtual town hall were also responded to on the spot live. In addition, those questions were also consolidated and added to the FAQs. So that's also available on the website for all creditors to take a look at. And maybe to explain what had happened in terms of the contents of the meeting, this is a page on page 8. Not only was the recording of the town hall made available, the PowerPoint slides that were also presented at that point in time were shared with all creditors. So a recording, the PowerPoint slides that were presented, as well as an FAQ are all available and provided for access by creditors. In terms of the contents of the virtual town hall, this is set out at paragraphs 17, 18, and 19 of the affidavit. An explanation was given to creditors of the objectives of the restructuring, an outline of the anticipated scope of work going forward. And there was also an explanation of the practical aspects of the restructuring, and as well as an overview of the Singapore court processes that may be used for the restructuring.
All right.
Yes. And perhaps, Your Honor, and just to take Your Honor through in terms of the content, the PowerPoint slide is set out at Mr. Darshan's second affidavit at tab 3. And this is at page 30 of the affidavit.
All right.
You'll see, Your Honor, that it sets out an overview of the background leading to the restructuring, what the current situation is at page 34 in terms of liquidity, the net asset value, the key reasons for the costs of the financial difficulties, what the scope and purpose of the restructuring is at page 36, the objectives of the restructuring to obtain a standstill, to stabilize the business, to explore options. At page 37, we also set out the elements of a successful restructuring in terms of what it may entail, to give creditors an idea of what to expect in a potential arrangement.
All right.
As well as the court processes over the page at page 38, explaining what the process is in Singapore, as well as possibility of other court processes in other jurisdictions. And also key timelines were also set out at page 40. An outline of the Singapore court process, a simplified structure in terms of a flowchart was set out at page 41. So everything has been broken down to the extent possible to make it as simple as possible for creditors to understand what the process is. In addition, at page 44, we do also set up the instructions for creditors to reach out to us in relation to their position on the application. And communications over the page to tell them how we would be continuing to engage them in terms of the website, other updates. So there is the Vault website blog. There's also the FAQs, the social media channels that includes Twitter, Facebook, and then also the email address where they can reach out to Vault directly. So in fact, if Your Honor looks at page 47 for the Q&A, so it's not that that the company just simply took questions live, but what they had done was to consolidate all the questions that had been pre-submitted, went through them, filtered them, to categorize them broadly, and dealt with them up front during the Q&A session in relation to the financial position. And these are very specific questions, Your Honor. If you take a look at page 47, where are the funds? What are the underlying reasons for the liquidity pressure? What is being done to protect the remaining assets of Vault? Who are the creditors over the page at page 48? What happens if moratorium is not granted? So it has been quite deliberate in terms of, explaining as much as possible the entire process and dealing with creditors' questions.
All right, thank you, Ms. Ng. Could I ask you at this juncture, your response to some directions the court had given? I had asked whether, I had asked for you to be prepared to answer me whether the applicant is prepared to provide financing for independent advisors or independent legal advisors and financial advisors.
Yes, Your Honor. And with that, Your Honor, because that's one of the reasons why I brought Your Honor through the efforts by the applicant to engage the creditors. And because of that, Your Honor, one it is in terms of the efforts, and what the company has done and will continue to do, is basically to set out as much as possible in terms of a very layman explanation of what the process is. And also because on the other side, in terms of a strain on the company's resources, it appears that there might be a bit of duplication in terms of what independent advisors can provide. So therefore,
so in essence, your position at this time is that the company is engaging sufficiently and you have no resources to arrange for the appointment of independent legal or financial advisors. Would that be accurate?
yes, perhaps just to clarify, it's not so much no resources, but the company feels that the resources can be better allocated for other purposes. In light of the fact that both the legal and financial advisors have been providing as comprehensive explanation as possible in relation to the process. And moving forward as well, when a scheme of arrangement is proposed, there has to be a very detailed explanatory statement. Town halls will continue to be conducted to explain the process.
All right, thank you. And what about the formation of a creditors committee of some sort? Has there been some thought for that?
So we'll be in Your Honor's hands in relation to that. If Your Honor feels that creditors committee might be useful to be set up.
All right, I appreciate the logistics. You have about 147,000 creditors, correct?
That's correct, Your Honor.
All right, I think for the moment, the town hall engagement may be sufficient, but I think it's something for the applicant to discuss with the creditors if there's any need for a creditors committee. So I'll leave it at that point and I'll see if there are any views expressed today or subsequently as well.
Yes, Your Honor, appreciate that.
Thank you. All right, anything else you'd like to raise, Ms. Ng?
Not at the moment, Your Honor.
All right, thank you. Hold on a moment. All right, at this point, I will turn to the lawyers first to see whether they have anything to add. The lawyers representing the creditors, some of the creditors at least. Mr. Russell Ng, anything to add?
Nothing from me, Your Honor. I've been instructed to attend this hearing on a watching brief only.
All right. All right, Mr. Haridas? Mr. Gokul Haridas, are you there? Yes.
Good afternoon, Your Honor. Are you able to see me on the screen?
Yes, thank you.
Your Honor, I would have interjected earlier, but I just wanted the proceedings to conclude. I'm actually Navin. I'm filling in.
Oh, sorry.
I'm filling in for Mr. Gokul Haridas because he had to attend a medical appointment for his daughter. But nothing on my end, Your Honor.
All right, thank you. Nothing. All right, thank you. All right, let me turn now to some of you who had indicated your support. I have taken note of some of the exchanges on the chat, but for the moment, let me just go through the list as compiled by the applicant's lawyers first. So grateful if you could keep it about 3 minutes or so. Let me have first Mr. Sahil Kumar. Are you present?
Not present.
All right, thank you. I'm sorry, I'm assuming, I'm guessing that most of the names are male, but I apologize if I'm mistaken. All right, is it Mr. Nishan Agarwal? present?
Yes.
All right, thank you. Mr. Agarwal, was it? Oh, sorry, Mr. Agarwal is not present.
He's present, but he's not speaking.
All right, so Mr. Agarwal is not speaking. Mr. Anubhav Yadav, I think I see you on screen.
Yes,
Yes.
nothing
yes,
from
Mr.
my
Yadav.
end. Nothing from my end, Your Honor.
Right,
Thank
thank
you.
you. Thank you, Mr. Yadav. And sorry, Mr. Taradas Vedavyas Pai.
Yes, Your Honor.
Sorry, hold on a moment, please. Sorry, I think I've lost track. You're on the screen. Mr. Taradas, yes. Pai, Mr. Pai, sorry. What do you wish to say?
Your Honor, I support this moratorium.
Yes. Support the moratorium. All right, thank you. Anything else you'd like to add?
No, Your Honor.
All right, thank you, Mr. Pai. I think, Mr. Agarwal, you are now on screen. Is there anything you wish to add?
Your Honor, if I may assist, I think Mr. Agarwal has mentioned in the chat that he cannot unmute, but he says
All right.
all good from his side. This
All
is
right,
at
thank you
4:48.
for highlighting me. Thank you. Thank you for highlighting that. All right, and Mr. Shivangi Priya,
He's not present.
not present. Mr. Amjad Mohidin,
He's not present as well.
not present. All right, thank you. All right, let me turn now, before I turn to those who turn to the rest. Don, I think I will try to respond to some of the other comments later, but I believe, sorry, there's someone else who wanted to speak, I believe. Mr. Damir Butmir. Can we bring Mr. Damir Butmir in, please? Thank you. Yes, Mr. Butmir.
Good morning, Your Honor. Thank you for accepting me into the court. I just wanted to make a few points. I was specifically named in the first affidavit because I'm one of the top 15 creditors of Vault. I'm specifically from Croatia. A few things I wanted to say from my perspective. I think communication from Vault so far to date has been good, so I wanted to confirm that. I had no previous relationship with Vault. I just have the funds with them, so communication definitely was good. I think in general, the moratorium for 6 months should be granted. I do have a financial background, so I understand the logistics. I know them to be profitable as far as I know, and they have loans going out that are going to come back in. So my preference would be to wait until the liabilities are less than they are now, rather than to wind up the company. One other maybe thing I would say is that the deal that they have with Nexo right now is unfortunately, in my opinion, exclusive, but there are other buyers in the market. So even if the Nexo deal doesn't work out in the next 60 days, I think there are other options that they are not allowed to mention, but they're there. The last thing, Your Honor, I wanted to say actually is I think a creditors committee would be a good idea. I think 147,000 creditors is too many, but it could be a court-appointed counsel of the top 15 or 20 creditors, and that's all I have to say. Thank you.
All right, thank you. Thank you, Mr. Butmir. All right, let's move on then to Mr. Brian E. Murray.
Thank you, Your Honor. I would just like to briefly speak about my experience with Vault. I will say I do support the moratorium, and I wanted to just, the only request that I have is I had just under 1 million USD on the platform, And I have experiences with other platforms like Voyager, Celsius, etc. And those platforms actually processed all the withdrawal requests prior to the platform shutdown. I had requested to remove $932,000 USD prior to the platform shutdown on June 29th at 7:35 in the morning. And I was told that those funds that request would be processed. The request was delayed, and on July 4th, the platform was shut down. All the other platforms did process the withdrawal request. I do understand the situation at hand, and I definitely do support the moratorium. I just wanted to mention that as other platforms did, the vault should process the request prior to the platform being shut down. Thank you, Your Honor.
All right, thank you, Mr. Murray. We'll come back to that in a short while. And next one, Mr. Shivashankar Swami Ritesh Kumar.
Not present.
Not present, thank you. Hold on a moment. All right, and we'll be coming to those in opposition shortly. Mr. Pratik Kamboj.
Not present.
Not present. Mr. Surab Dhawan.
Not present.
Mr. Tushar M. Kamath.
Not present.
Mr. Dhanasri Saita Nyoto.
He's present.
All right, sorry, Mr. Nyoto.
Good afternoon.
Good afternoon. Yes, Mr. Nyoto.
Hi, good afternoon. Your Honor, thank you very much for this, Your Honor, and for everyone, all the counsels that's involved in this. I appreciate your time and effort. The reason why I'd like to state whatever I've gone through with Vault is I hope that others who are going through the same experience can at least gain some clarity and explanation. I have funds with Vault, but I also have a loan with Vault. Basically, what I did before the platform went under was that I have used my Bitcoin as a mortgage for me to be able to get a loan from them. What happened was that I have additional funds in the platform which can be used to top up the loan. However, because of whatever Volt was going through, so I was not able to use that funds to top up my loan, and hence my loan was liquidated. So in such a scenario, I am not getting any proper explanation from Volt, neither am I getting any proper remedial measures to what I'm going through. So I feel that, unfortunately, in this case, I feel that I have not been fairly treated. And on top of that, what they have done is they have gone back on their words. I mean, my asset is, I was only supposed to be liquidated if it falls to 105%. However, they changed the terms and conditions while going through this entire process.
All right.
It's very one-sided, yeah.
All right. Thank you, Mr. Nyoto.
Grateful.
All right. Thank you. Hold on a moment, please. I think, hold on. I'm not sure someone else wanted to speak. All right. We have Mr. Arul Patiba, who has wanted to address the court. Mr. Arul Patiba. Sorry, was it Mr. Arul Patiban Velasamy, was it?
Yes.
All right, thank you. Yes, Mr. Arul Patiban Velasamy. Sorry, I'm not sure if you're muted. All right, thank you. I'm sorry, Mr. Velasamy, I'm afraid I still can't hear you. All right, Mr. Velasamy, I'm afraid there seems to be some difficulties. Perhaps what I could propose to you is this. Could you send in your message? You can indicate in the chat whether you support or object to the moratoria and your reasons. But on top of that, if you have anything else that you wish to say, you can send in an email to the applicants and I will ask for them to convey it to me. So know what you have on your mind right now. But would you be able to enter the chat whether you wish to say anything in support or objection to the moratorium?
Your Honor, if I may assist as well, I noticed the chat box that Mr. Velasamy had made some comments at 4:35 p.m.
Yes. All right, right. Yes, thank you. All right, sorry. So Mr. Velasamy is saying that the families and creditors are in financial difficulties. About 80% are Indian. And yes, and you're asking for some form of small relief, 5% or trading and some activity. And yes, and I think you have some concerns about the management by the company. All right, Mr. Velasamy, I understand and you have my sympathies for the position you are in. Unfortunately, in the present proceedings, all I can do as the judge is to order the moratorium to be extended or to be terminated. I am not able to make an order for the company to make payment of whatever amount. I can encourage the company to try to work out a solution, especially for some of the smaller creditors, but that's not always possible. So I'm afraid I'm constrained by the structure of the law. I can only allow the moratorium to continue or end the moratorium. And I note that you are opposing the extension of the moratorium. I will take that into account in how I weigh everything, but I'm afraid that's the extent of what I can do today. But if you would like to expand further on your circumstances, I will ask for you to email to the applicant and I'll ask them to convey it to me. All right, Ms. Ng as well, if you could do that.
Yes, Your Honor, will do so.
All right, thank you. But then let me catch up on the rest of the chats. All right, and some of you have also indicated, some others have spotted, right? Thank you. All right. All right. All right, I think some of you have raised hands. If any of you wish to speak, could you put into the chat what you wish to address me on? I think there's some raised hands. All right, if not, I will need to proceed. At this point, let me come back to Ms. Ng and ask her to respond to some of the comments made and some of the reservations that have been raised. And also particularly Mr. Murray's, I think, concerns as well. And I think some of the other concerns, including the raised by Mr. Vasani. All right, let's carry on. Ms. Ng, would you like to respond?
Yes, Your Honor, grateful for that. And with that, on behalf of the applicant, I do thank the creditors, for their views, which of course the company will take into consideration. I do note that, various of the requests are specific to each of these creditors. And perhaps what I could do is to relay that to the company, and we will address them specifically outside of this hearing, if it's specific to those creditors. And in relation to the comment about the creditors committee, I think as I mentioned, we are in your honor's hands. Perhaps at the appropriate juncture further down the road, that may be more appropriate, and we will be in your honor's hands in relation to when that might be. And I think insofar as I think there was also a reference that there was some change in the terms of business along the way. That's something that I'm not aware of, and that's something that we will look into, and we will address those specific queries that have been raised by creditors.
All right. All right. Yes, I think a number of creditors have not surprisingly indicated that they are in financial difficulties. Again, it is something unfortunate, and we do see this a lot in moratorium cases. Sometimes we have asked the applicants to try to see whether they can allow some payments to go out. I'm not sure that's feasible. It will vary according to the kind of business and kind of a financial situation that they're in, but I would ask the applicant to consider whether there can be any minimum withdrawal permitted. But as I emphasize, I am not able to order this, but I would encourage the applicant to consider if any withdrawal at all can be permitted in the coming weeks. Right?
Yes, Your Honor. We'll take it back and consider.
All right, thank you. And in relation to the creditors committee, I will ask the company to also consider the logistics and process of appointing a creditors committee, and perhaps to let me see a framework in. Would 3 weeks be reasonable, Ms. Ang?
Yes, Your Honor. Perhaps can I ask for 4 weeks so that there is also a little bit more time to engage the creditors. I think what might be useful after this, subject to discussions with the management as well as the financial advisors, is whether a virtual town hall can be held before we respond to Your Honor.
All right, you may be having a town hall. All right, we'll be having a town hall. All right, hold on. I think Mr. Murray wants to come in to respond to you. But before that, let me just make sure I've raised some other points. All right, and Mr. Nyoto's concerns you will address separately, will you?
Yes, Your Honor. So for those specific queries, I think that's relating to Mr. Murray. He did mention his circumstances as well as Mr. Noto. We will respond separately after this.
And certainly also, I think sorry, I've forgotten the name, Mr. Rai, was it? I think there's some others from the chat. What we will do is I will provide, I think this can be done. We will try to provide you with a copy of the chat, Ms. Ng. So you can also put it up on the site. I think that can be done. Let me check on that. But sorry, Mr. Velusamy, I think I will ask Mr. Velusamy to send in his queries through you, and I will examine it by letter. All right, thank you. All right, so I think there are a few others have indicated that they need withdrawal of funds at this time. Mr. Velusamy, Mr. Dagani, and all. All right.
Yes, I get into consideration, and maybe I should just highlight that if any withdrawal of funds will be allowed, I mean, it has to be fair to all creditors. So it will not be in relation to specific creditors, but the company will consider whether that's possible across all creditors.
All right, all right. And then Mr. Kumar has some suggestions about the creditor committee as well. All right. All right, sorry, Mr. Murray, you wanted to raise something, Mr. Murray?
Yes, thank you, Your Honor. So I'd like to add that my attorney and I did have a 15-minute phone conference with Mr. Darshan, And we did explain our situation regarding the request of withdrawal funds prior to the platform being shut down. He said he was not aware of this, but was disturbed by this information. And like I just said prior to, he said that we would hear some type of communication back regarding that. That was approximately 2.5 to 3 weeks ago. We've had no communication back from Vault.
All right. All right. All right. So I'll ask for an update on these issues raised by Mr. Murray, as well as Mr. Velusamy and Mr. Nyoto in particular, and whatever else might be raised in the chat group. All right. Thank you.
Yes, Your Honor.
All right. All right. Before I proceed further, does anyone wish to address me in terms of the criteria for the opposition? For the criteria for the granting of the moratorium extension, namely, in most cases, the absence of creditor support, of the absence of sufficient detail in terms of or likelihood of success or acceptance of the proposal. Before I make my ruling. All right. All right. Thank you. All right. Anything else, Ms. Ng?
Nothing from me, Your Honor.
All right. Thank you.
Your Honor, I do note from the chat box, there's a Mr. Stephen Song who would like to make a
Oh,
comment.
sorry. Was there one? Sorry. Mr. Stephen Song. Yes. Is there Mr. Song?
Yes.
Oh, yes, Mr. Song.
Hello, Your Honor.
Yes.
Thank you for having me. I am cautiously in support of the moratorium, but I would like to see some conditions placed on the moratorium. So, for example, that Vault must provide regular updates or Q&A and town halls, etc. That there should be some basic fiduciary duties to the creditors. One of the questions that I have submitted previously to Vault and I have not received an answer about yet is that if their primary plan is the acquisition by Nexo, please be advised that under the Nexo terms and conditions, they do not accept customers from all jurisdictions. So for example, USA, Canada, Australia, Estonia, and some other countries are prohibited from using certain services on the Nexo platform. So it is unclear to me what would happen to Vault customers from those jurisdictions in the event of the Nexo acquisition. And I would like to see that any resolution that Vault seeks with Nexo would be fair to all the creditors from all the jurisdictions where Vault operates.
Right. All right. Thank you, Mr. Song. Thank you. All right. So that's another point to note. Hold on. I think there might be another one. All right. I think there's some other raised hands. Sorry, Annie, can you type out the names for me? I may not be able to see it clearly on the system. All right, sorry, Mr. Narendra Kumar, sorry. Mr. Narendra Kumar, did you wish to say something? Narendra Kumar. All right, sorry, and then if not, then Mr. Gautam Madan Kunde. Sorry if I mispronounced that. Mr. Gautam Madan Kunde. Sorry, all right, thank you. If not, then well, Mr. Kumar, I think there's a microphone. There should be a microphone tab in this app. Can we unmute Mr. Kumar, please, Annie? Mr. Narendra Kumar is in the chat.
Yeah, hi. Am I audible now?
Yes, thank you.
Thank you so much. I must congratulate the judiciary of Singapore and thank you so much for taking this issue. This is a very important issue. And I'm although based in UK, and there are lots of investors like me who put the faith in Singapore and its mechanism. And that's why we did not even hesitate from other countries to invest in a company like Vault. I have exposure to this for this company for more than 160,000 US dollars. And definitely the things are going in the positive direction. But one of the things which I really wanted to emphasize was that it will be really great if the interests of creditors are protected, as plenty of people are small time or middle class income people who all have invested their hard-earned money, and they are really, really dependent on that kind of money. And the other thing also will be is like people are looking forward to this kind of judgment, what is going on, and it will be also a matter of faith that if it is going to be taken care and all. So it will be a great example even in the future. For example, if there's a committee which is made of the creditors and all with adequate and good representation from the judiciary, if something like that will be really great. Thank you so much.
All right, thank you, Mr. Kumar. And we have Mr. All right, sorry, I think that's the last of it. All right, so I think we will see what can be established in terms of the creditors committee. There'll be some issues because of the different amounts invested, and I think different situations, nationalities, where you're located, or something. But hopefully we'll be able to get through that and come up with a structure so that all of you will feel that you have a say in the process. I think town halls are one mechanism, but perhaps the committee will also be useful. Now, in relation to the specific application today, I will proceed to give my pronouncement. I am concerned that a 6-month moratorium will not give adequate, will not allow for adequate supervision and monitoring. I do appreciate that sometimes required to put things together, but in the circumstances, I will only allow an extension of 3 months at this time and require the company to reapply for the extension before the expiry of that 3 months. And at that point, you have an update on how things are progressing and also how the engagement is continuing. Now, for the benefit of Nexon or whoever else wishes to invest in the company, I can indicate that the court will be ready to extend the moratoria as long as good faith efforts are pursued and that creditors' support remains or continues to develop. All right, so that can be conveyed to the investors. I'm giving you 3 months. It's just really for me to monitor things rather than 6 months straight off. But I will be amenable to extension if credit support continues or to develop or to be strong and there's continued engagement. All right, Ms. Ng?
Grateful, Your Honor. And can I clarify that the 3 months extension runs from today?
Yes, from today. From today, so let me just do the timelines. So this is the 1st of August, so that will be this. All right, roughly 3 months. I'll try to round it up to the nearest working day first. 1st September, 1 month. 1st. All right, I'll give it to the 7th of November. All right.
Grateful, Your Honor.
All right, 7th November. It's extended to 7th November. Application for extension to be made before then in good time. All right. And could I have a case conference in Oh no, given the numbers, I'll just leave it without case conference, but there may be an ARPTC in the meantime to check on progress and logistics for the next hearing. All right, Ms. Ng?
Grateful, Your Honor. And can I ask in relation to the extension application for that the moratorium be extended to the disposal of the extension application, Your Honor?
Oh, I thought I was doing that by giving you to 7th November.
Appreciate.
All right.
Yes,
I will, if need be, I will give interim extensions if needed, if we are not able to fit the hearing accordingly. All right.
Grateful for that, Your Honor.
All right. So to recap for all of you, I'm giving approximately 3-month extension only to 7th November. The applicant needs to file in good time before then. Hopefully we'll be able to fit the hearing before the 7th of November, but sometimes because of scheduling issues, if I'm not able to do that, I may give a short interim extension in the meantime. Now, by that date, I hope to see and will have received the information and updates from the applicant in relation to the establishment of the creditors committee, and also for them to update me whether any withdrawal or other mechanism can be put in place for those who are in need, and for their responses to the queries raised today. So all of this, can you give it to me? Given a deadline for the queries and all that to be responded in 2 weeks, can all this information be provided to the court in about 4 weeks, Ms. Ng?
Yes, Your Honor.
All right. So in 4 weeks' time, they'll report back to me on the plans of the creditors committee, whether they think it is possible to have any withdrawal of any amount, and for the responses to the specific queries raised today by various people.
Yes, Your Honor, got that.
Right, thank you. Let me see. And in terms of the financial affairs information under subsection 6, Ms. Ng, when do you think you'll be able to comply with that?
Yes, Your Honor. Can I ask, in relation to the management accounts, we do need a little bit more time, and that's subject to reconciliation within the group. Can I ask for 8 weeks for that? But for the cash flow forecast, we are able to do it earlier. We were asking for 2 weeks to comply with that one. And it's similarly for the valuation of the significant assets, 2 weeks.
All right, so cash flow and, sorry, valuation of assets in what, 2 weeks?
In 2 weeks, Your Honor.
So for cash flow evaluation of assets in 2 weeks, and the management accounts?
In 8 weeks, Your Honor.
In 8 weeks, all right, from today. All right, those are requirements under the Act. So I assume you'll have no issue if such information is also provided to your creditors through your normal channels?
That should be the case, Your Honor. If there's any sensitive information, we will reach out to Your Honor or to the court for directions if there's need for any reduction.
All right, directions to be obtained for any reduction. All right, so all of you creditors should be able to get the financial information, cash flow evaluation of assets in 2 weeks, management accounts in 8 weeks from today. Have we covered all the requirements of subsection 6, Ms. Hunt?
Yes, perhaps, Your Honor, just in relation to item B, if the company acquires or disposes of that, of course, will be complied with as amended.
All right. Oh, sorry, we had one query, I think from Mr. Nima Lama, was it? Mr. Nima Lama, did you wish to say something? Sorry, Mr. Lama, I think if, again, if you have any things, all right, perhaps you could send in by letter to Ms. Ng and she'll convey to me as well. All right, let me turn now to the specific orders, just to make sure I've got everything covered. Right. Right. So in terms of the order in term, prayer
Hello,
one.
is audible?
Oh, sorry, Mr. Ida Lama, was it?
Yes, sir.
Is that all right? What did you wish to say?
Okay, thank you for your giving me an opportunity, Your Honor. So actually, we are going. The board is going under the tough challenges, as we already understand that. I would like to point about the creditor committee to be formed. That it should be from the mixed creditors, like from the large cap, medium cap, and small cap, because most of them are medium and small investors. And I wish that the judiciary and the board teams can get creditors from the both all of them, all of the sizes as a mix, so that everybody will get the equal justice for that in the to raise the voice in the credit committee. And regarding the short moratorium extension, I would really support for that, but not for 6 months, as your honorable has already approved for 3 months. I wish that it is very good decision that you the judiciary has made. And it should be monitored in time between by the judiciaries, because we creditors don't have any like paneling to be discussed about that, about how the progress are going on and what are the progress being made. So I wish, and I would like to request the judiciary to keep on monitoring on their progress. So much, Your Honor.
All right, thank you, Mr. Lama. All right, but I think one of you noted that your calculation shows that extension to November is 4 months. It's approximately. I'm just taking a close date to 7th of November to allow them enough time. So it's basically an extension to 7th November in this instance. Thank you. All right. All right. So there'll be some work required in terms of the creditors committee. I'm afraid I have to draw matters to a close. I need to make my pronouncement today. All right, I have one last address to the court by Mr. Vidya Dagani. Did you wish to say something? I'm afraid this will have to be the last one. Mr. Vidya? Yes, Mr. Vidya, what do you wish to say?
Hello, Your Honor. Thank you for this.
Sorry, Mr. Dagani. Sorry. Yes, Karen?
No, I just wanted to ensure that you saw my message in the chat box. That is all.
All right, thank you. Right, thank you. All right, don't worry, we will take note of the chat matters and we'll try to address them for the next hearing. All right, so the moratorium will end on the 7th of November. The point of it is the application for extension has to be made before then. On occasion, if we're not able to schedule the hearing by 7th November, I may give a short extension just to allow the hearing to be held. All right, thank you. All right, the applicant will be able to keep you well informed of the dates, and we will probably disseminate information for the hearing in the same way. All right. All right, thank you, everyone. Then let me just make the official pronouncement. So having heard the submissions of the applicant and considered the various addresses to the court is of the view that the extension should be granted of the moratoria to 7th November 2022, and I otherwise grant order in terms of prayers A to F of prayer 1, and make no orders to prayer 2, and grant order in terms of prayer 3. All right, Ms.
Grateful, Your Honor.
All right, anything else?
Nothing at this moment. I said to thank you, Your Honor.
All right, thank you. So I would encourage the company to continue to engage with the creditors and to also consider what I've suggested, the formation of the credited committee, bearing in mind the different situation of the different groups of creditors, as well as to consider whether any possible range of withdrawals can be permitted, and to address the concerns raised by the various creditors today. All right.
Yes, Your Honor.
Thank you all. Thank you all. All right, thank you. I will take note of the comments in the chat, but I'm afraid I have to draw the matters to a close. If you have, any of you have any further remarks or comments, you may also convey it for the attention of the court through the channels used by the applicant. All right. Otherwise, thank you for your time. If nothing further, court is hereby adjourned. Thank you.
Thank you, Your Honor. Good day.